Retaliation, in the context of federal workplace discrimination laws, begins when an employee engages in protected activity, such as filing a verbal or written race discrimination complaint. The complaint could be filed internally with a supervisor, manager, or the Human Resources Department. Or the complaint could be filed externally with a local or state agency or the U.S. Equal Employment Opportunity Commission. The employer quickly reacts to the employee's complaint with harsher treatment, for instance, by demoting the employee. Harsher treatment could include termination, demotion, reassignment to a less desirable position, failure to promote, or a reduction in work hours. Ultimately, any employment action that would significantly deter an employee from engaging in protected activity can constitute an adverse employment action. Retaliation is merely an employer taking revenge against an employee or group of employees. However, employers have access to human resources professionals and lawyers who can advise them on how to retaliate against an employee without appearing to break the law. The employer creates a pretext for treating the employee more harshly. An employee who always received satisfactory job performance evaluations begins to receive less than satisfactory job performance evaluations, which eventually leads to a demotion or termination. The employer can then allege that the employee was demoted or terminated due to unsatisfactory job performance. The employer's defense is that the employee would have been demoted or terminated anyway. The Supreme Court declared that an employee must establish that, but for the protected activity, the adverse employment action would not have occurred. In order to prevail on their retaliation claim, the employee must demonstrate that the employer's allegation of poor job performance is pretext or an excuse for retaliation. In other words, the employee must prove that the employer is lying. An employee who believes their employer is retaliating against them should consider filing a complaint with the Equal Employment Opportunity Commission. Retaliation has been the #1 complaint received by the EOC. An employee can file a separate claim for discrimination, say race, and a separate claim for retaliation that is related to the race discrimination claim. Furthermore, an employee can prevail on a retaliation claim even if the discrimination claim is dismissed, and vice versa. The process of proving retaliation begins with establishing 3 elements which collectively create what is called a prima facie case of retaliation. 1. The employee engaged in protected activity. 2. The employer subsequently took a materially adverse employment action against the employee or the employee's spouse or family member. And 3. The adverse employment action was causally connected to the protected activity. The third element, a causal connection, is generally established by temporal proximity. In other words, the adverse employment action occurs within days or weeks of the protected activity. In most cases, a gap of several months would be too long to establish temporal proximity.